lawsuits against police officers nationwide have cost over $3.2 billion in the past 10 years. So that's billion with a P. The largest police brutality settlement on record is by somebody named Randy Cox. Randy Cox was left paralyzed after being injured while being transported in the back of a police van. And in that case, the city agreed to pay a $45 million settlement. That's the highest award that I am aware of. Welcome back to the Ask Rusty Law Podcast. I'm your host, Attorney Rusty Messer with Big River Trial Attorneys. Today, we're tackling an important and often misunderstood topic, police brutality lawsuits. So this is a subject that affects communities across America, and understanding your rights is crucial. Whether you've experienced an encounter with law enforcement that maybe you felt was wrong, or maybe you simply want to know what protections exist under the law, this episode is for you. So we are going to break down what actually constitutes police brutality and what doesn't. We're going to talk about what you need to know and what you need to prove to win a case. And we're going to talk about the very real challenge of qualified immunity. I'm also going to discuss some eye-opening examples of settlement amounts that have been awarded in these types of cases. So let's dive in. Let's start with the basics. When people hear police brutality, they often think of the most extreme cases that make national headlines. But legally, the term we're really talking about is excessive force. So what exactly is excessive force under the law? So simply put, excessive force is when a law enforcement officer uses more force than is reasonably necessary to control a situation or to protect themselves or others from danger. So now here's the key. It's not about whether the officer had bad intentions or whether they were having a bad day. The legal test is based on what's called an objective reasonableness. Courts are going to ask, would a reasonable officer in the same situation with the same information have used that amount of force? Now, this standard comes from a landmark Supreme Court case called Graham v. Connor. It's a 1989 case. And in that case, the court said, we have to judge an officer's actions from the perspective of a reasonable officer on the scene rather than with a 20/20 vision of hindsight. So, look, police officers have to make split-second decisions in tense, uncertain, and rapidly evolving situations. The law gets that. But, and this is important, recognizing that officers face difficult situations doesn't give them unlimited authority. Your Fourth Amendment rights protect you from unreasonable searches and seizures, and that includes protection from excessive force during an arrest or a detention. So let's talk about the different types of excessive force. So excessive force can take many forms, and it's not just about deadly force. So that's like really the most serious type, right, when somebody dies. But let's look at some examples of what courts have found to be excessive. First, there is non-lethal excessive force. So this includes things like beatings with batons, punches, strikes, the use of a taser, or maybe rubber bullets, chokeholds, any type of asphyxiation or choking, even applying handcuffs too tightly so that they cause injury. So just because the force is non-lethal doesn't mean it's not excessive. Then there's deadly force. So this is the use of force likely to cause death or serious bodily injury. So the legal standard here is very specific. Deadly force should only be used when an officer reasonably believes that a person poses an immediate threat of death or serious bodily injury to the officer or to others. So deadly force is meant to be a last resort. And here's something a lot of people don't realize. Excessive force doesn't require that you are severely injured. You can have a valid claim even if you weren't physically harmed. For example, if an officer pulls a gun on you and you were standing peacefully on a sidewalk, minding your own business, and a reasonable officer wouldn't have come up and put a gun in your face, that's excessive force, even if the officer never fires the weapon or physically contacts you. All right, let's talk about what officers' actions do constitute police brutality. So, not every use of force by police is excessive. Police officers have a legal right and often a duty to use force in certain situations. So you need to understand what doesn't constitute excessive force, right? Because this is just as important as understanding what does. The Supreme Court has recognized that officers sometimes need to use physical coercion to make an arrest or to control the situation. As the court put it, not every push or shove, even if it may later seem unnecessary in a judge's chambers, is actually a Fourth Amendment violation. So when is force justified? Courts look at several factors to see when force is justified. First is going to be the severity of the crime. If someone is suspected of a violent felony, officers can reasonably use more force than if someone is suspected of, let's say, like a minor traffic violation. A second factor is going to be whether the suspect poses an immediate threat. So if somebody is actively threatening officers or actively threatening others with a weapon, the use of force and even deadly force in that situation may be justified. A third factor is whether the suspect is actively resisting arrest or attempting to flee. If someone is fighting with the officers or running away, some level of force may be necessary for the officer to actually make an arrest, assuming that the officer, in fact, has a right to make an arrest. So let me give you a real example. In a 2007 Supreme Court case, the court looked at whether it was excessive force for an officer to use his police cruiser, right, his car, to ram a fleeing suspect's car during a high-speed chase. And even though this posed a high likelihood of serious injury or death to the suspect, the court found it was reasonable given the threat that the high-speed chase posed to innocent bystanders, right? The court said the police need to stop this guy. Another example is if someone has already surrendered and they're handcuffed and they are fully compliant. So any use of force beyond what's needed to maintain control would likely be excessive. But if that same person is actively struggling, officers can use reasonable force to gain control, right? So the key here is the proportionality of the force. The amount of force the officer uses must match the situation. That's the standard that courts are going to apply. So if a person is detained, not a threat, in handcuffs, obviously a lower level of force is going to be used or should be used in that situation. All right, so let's say you believe you've been subjected to excessive force. What do you actually need to prove in court to win your case? And this is where things get very detailed, so stay with me. So a lot of claims are brought under a legal framework called Section 1983. And this is a federal law, and it's where most police brutality lawsuits are brought. And this law was passed way back in 1871 during the Reconstruction era. And it was created to give people a way to sue government officials who violated their constitutional rights. So the full citation is 42 USC 1983, but everybody just calls it Section 1983. To win under Section 1983, you need to prove two main things. First, you have to prove that the officer was, in fact, acting under what they call the color of state law. So this basically means they were using their authority as a police officer, even if what they did was actually illegal. Like, for instance, if an officer makes an arrest without probable cause, they're still acting under color of state law because they're exercising their power to make an arrest. And this requirement is almost always met in police misconduct cases. So even if they're using their authority to break a law, like make an unlawful arrest. So second, their conduct has to deprive you of rights secured by the Constitution or federal laws. So for excessive force, this usually means your Fourth Amendment right to be free from an unreasonable seizure. Now, in a civil case, which we're talking about civil cases, not really criminal cases here, right? In a civil case, the burden of proof, what you're going to have to show is called a preponderance of the evidence. And this is a fancy way of saying it's more likely than not. Sometimes it's called 51% that your rights were violated. So it's not like a beyond a reasonable doubt like you see in a criminal cases. So it's a lower bar. But even so, these cases are notoriously difficult to win. And in a minute, I'm going to explain why these cases are so difficult to win. But before I do, let's talk about the evidence. So some of the best evidence that we're seeing nowadays are video footage. And this can be body camera footage. This can be dash camera footage. This can be surveillance camera footage from a store or a home. It can be cell phone footage from bystanders. All of this can be incredibly powerful. So video evidence from body cameras and bystanders with their cell phones has really reshaped the police misconduct litigation because it makes it so much harder for officers to dispute what actually happened. It's no longer just one person's word against another when there's a video. Another piece of evidence are police reports and records, initial incident reports, use of force reports, arrest reports, any internal investigation documents. So these would have been created at the time of the incident or soon after, before a lawsuit was filed. So this gives them some credibility. As always, credible eyewitness testimony is a good thing to have. If there are people there who saw what happened, this can make or break a case. Another important piece of evidence can be medical records. So if you were injured and you go to the hospital, now there's documentation of maybe both physical and psychological injuries. So this helps establish the harm you've suffered. You're almost always going to need expert testimony. This is somebody who's trained in police practices, who can testify whether the officer's actions were reasonable under the circumstances, or more importantly, whether they followed standard police practices and standard policing guidelines. So let's talk about who can be sued. So you are not limited to just suing the officer who directly harmed you. Under certain circumstances, you can also sue maybe other officers who were present. So this is something called bystander liability. Remember, officers have a duty to protect us. So if another officer knew a constitutional violation was happening, then that officer had a reasonable duty to prevent it if it was something that the officer could have prevented. And so if the officer chose not to act, they can be held liable too. And this is particularly common in excessive force cases. You can also sue supervisors, though this is something called supervisory liability. Though they weren't there, if a supervisor knew or should have known that an officer was engaged in conduct that posed a pervasive, like a high risk of constitutional violation, if a supervisor knew this officer was prone to that, then the supervisor should have intervened. Supervisor should have retrained. So there are situations where the supervisor can be held liable. And almost always you're going to sue the police department or the municipality. But you're going to have to show that a department policy or a custom or a practice allowed your rights to be violated. So maybe the department failed to properly train officers, or they had a pattern of condoning excessive force. These claims, they're called Monell claims after a Supreme Court case. They're tough to prove, but they are crucial if you want to recover damages from the deeper pockets of a city or a county or a parish, as we call them in Louisiana, or a municipal government. You can also bring claims under a state rights constitution. So these are common law claims or civil law claims like assault, battery, false imprisonment. These are going to be subject to a time frame. In Louisiana, it's going to be probably 2 years from when it happened under the new law that we have now. But these are claims that you're going to want to include. Now let's talk about what gets many of these cases thrown out and it's the biggest obstacle in police misconduct cases, and this is what is known as qualified immunity. So qualified immunity is a legal doctrine that's been called everything from a shield for police to a license to violate rights with impunity. So let me break down what qualified immunity is and why it is going to matter so much if you believe you have an excessive force case. So qualified immunity is a court-created doctrine. It's not in any statute. And this doctrine says that a government official can't be held personally liable for violating someone's constitutional rights unless the victim can show, one, that a constitutional right was in fact violated, and two, that the right was clearly established at the time. And so the second part is where things get tricky. So what does clearly established mean? And this is what courts struggle with. Courts have interpreted it to mean that there must be a prior case with very similar facts where a court has already said that conduct was unconstitutional. And it has to be very similar facts. The courts are not your friends on these cases. Very often, they're looking for ways to throw your claim out. So the Supreme Court introduced the qualified immunity doctrine back in 1967 in a case called Pearson v. Ray. And it's supposedly there to protect government officials from frivolous lawsuits. But in a 1982 case called Harlow, the court dramatically expanded it to protect even government officials from malicious conduct, as long as they didn't violate what's called clearly established law. So let's talk about the clearly established law problem. Here's where qualified immunity becomes very, very difficult to overcome. So let me give you some real examples of how courts have applied this term clearly established law and see what they do with this requirement. In 2014, the Nashville Police Department released a police dog on a suspect after he had surrendered and he was sitting on the ground with his hands raised. The man sued, and it was determined that to meet the clearly established law requirement, his lawyer went and found a prior case where a court said it was unconstitutional to release a police dog on someone who had surrendered by lying down. So you would think that was enough, right? But you'd be wrong. The court said that the precedent didn't clearly establish it was unconstitutional to release a dog on someone who had surrendered by sitting with his arms raised, because that other case talked about somebody who was laying down. And in that case, the officers got qualified immunity. In another case, this was in Fresno, California, where officers allegedly stole $151,000 in cash while executing a search warrant. And the victim, the people whose house was being searched, were never charged with the crime. When they sued, the court said that since there was no clearly established law specifically saying officers violate the Fourth Amendment when they steal property during a search warrant, the officers couldn't be successfully sued. And the court even went on and acknowledged that they said, look, what they did was morally reprehensible. If it occurred, right? Because it wasn't established. But they said that even if it occurred, it didn't violate a clearly established law, which would seem ridiculous, right? Because we're talking about a theft from someone's home. So you can see the problem. The standard is so specific that unless there's a case with nearly identical facts already on the books, very often officers can escape liability. And here is the crucial irony. If some innovative or unique misconduct hasn't been addressed by the courts before it gets a free pass. As one study found between 2015 and 2019, courts granted qualified immunity in 54% of appeals, in 54% of their cases, and appeals only denied it 26% of the time. But let's talk about the overall impact on justice. Qualified immunity doesn't just protect officers. It denies justice to victims. So if an officer gets qualified immunity, the case is dismissed. The victim receives no compensation. The victim doesn't get a day in court. Nothing happens. And because the case doesn't result in a ruling on the merits, it doesn't create any new clearly established law for future cases. So it's a vicious cycle where courts are using the absence of past cases to prevent justice in new cases. Supreme Court Justice Sonia Sotomayor, she's been very outspoken on this, noting a disturbing trend of siding with police officers using excessive force. And she's described qualified immunity as sanctioning a shoot first and think later approach to policing. There have been efforts to reform or even eliminate qualified immunity. Several states, including Colorado and New Mexico, have passed laws limiting it at the state level. Congress has considered legislation like the George Floyd Justice and Policing Act, which would have ended qualified immunity for law enforcement, but that legislation stalled in the Senate and didn't go anywhere. And the Supreme Court has repeatedly declined to revisit the qualified immunity doctrine. If you're suing under a state law, qualified immunity may not apply. Many states have passed either statutes or their own state law to put in place some different level of protection, very similar to qualified immunity, trying to create some immunity for a violation of a constitutional act. Right? But there are ways around that too, if it involves breaking a law. Just another challenge. So let's talk about the money side of these cases. If you do overcome all the hurdles and you win a police brutality lawsuit, or if your case settles, which sometimes happens, what types of damages can you recover? So there are several categories of damages that you should be asking for. One are compensatory damages, and these are meant to compensate you for your actual losses. So here we're talking about medical expenses, past medical expenses, future medical expenses, if you're going to need more treatment, rehabilitation, therapy, things like that. Lost wages, if you missed work or you're going to miss work because of your injuries. Then you get into things like pain and suffering, emotional distress, mental anguish, loss of enjoyment of life, which is not being able to do the things you like to do because of the injuries you suffered in the attack. And another type of damages are called punitive damages. These are designed to punish the officer and deter similar conduct in the future. Under federal law, you can get punitive damages if the officer acted with reckless or callous indifference, and that's an important legal term. So this has to be a reckless or callous indifference to your constitutional rights. And sometimes under state law, you can get them if they acted with malice. It varies state to state. So here is something crucial. Punitive damages can only be awarded against individual officers, not against the government. And you can only collect them from the officer's personal assets. So if a jury awards you $500,000 in punitive damages, you very often will be limited to going after the officer who probably doesn't have that type of money. Again, under state law, that can vary. So the government won't pay punitive damages on the officer's behalf, or sometimes it may, but there may be arguments that it's not obligated to. Attorney's fees are another big deal. Under Section 1983, if you win your case, you can recover your attorney's fees in addition to your damages, like your compensation. Right. This is huge because it means lawyers can afford to take these cases even when the damages might not be enormous. So it provides an extra incentive for lawyers to come in and help hold these agencies accountable. In some cases, you might also be able to seek what's called injunctive relief, and this is a court order that requires a police department to change its policies or to change its practices. Another type of relief is called declaratory relief, where a court makes a declaration about what the legal rights and obligations are, and tells the police officer, hey, these are the rights that you owe to people. Now let's talk about the limits on damages based on who has to pay. If you are suing under a state law, there are likely caps on damages. Like here in Louisiana, there is a $500,000 cap on a claim against a municipality. So that's the most you can get, not counting interest. Right? There are no limits under this federal law under Section 1983. So most of these claims are going to be brought in federal court for that reason. And these judgments, even if you get a judgment against the individual officer, the payments usually come from the municipality or the police department or the city or something like that. A lot of times these cities or municipalities or agencies are self-insured. Some have commercial insurance, and very often with police departments, they're part of some sort of a fund or some sort of a trust that is like where a group of agencies have gotten together to be self-insured. So there's a lot of public debate over this lately. We've seen the police shootings up in Minnesota by federal agents, and past years have seen lots of other actions, violations of constitutional rights, where people are getting injured, people are getting shot, people are getting choked, people are not properly restrained in the back of some sort of vehicle while they're being transported. But let's talk about some of the actual cases, to talk about some of the awards you can get in these types of cases. So according to data compiled by the Crime Report, and lawsuits against police officers nationwide have cost over $3.2 billion in the past 10 years. So that's billion with a P. The median payout on a police brutality claim is $17,500, but the high-profile cases often get up into the seven figures. The largest police brutality settlement on record is by somebody named Randy Cox. Randy Cox was left paralyzed after being injured while being transported in the back of a police van. And in that case, the city agreed to pay a $45 million settlement. And that's the highest award that I am aware of. There have been some other pretty substantial awards. Some other notable examples are Edward Bronstein, where his family received $24 million after a fatal encounter with the California Highway Patrol. The family of Christian Glass received $19 million after a deputy killed him during a mental health crisis in Colorado. There was the family of Elijah McClain. They received a $15 million settlement after his death following a violent arrest by the Aurora, Colorado Police Department. Jamal Truelove, he was wrongfully convicted of murder and was awarded $13.1 million by the city of San Francisco, or against the city of San Francisco, rather. Eric Garner's family received $5.9 million after he died in New York City from a chokehold. Going way back to Rodney King, he received $3.8 million for the infamous beating in 1991. But not all of these cases involve millions. There are many settlements in the tens or the hundreds of thousands. There's a gentleman named Tony Martinez. He has Down syndrome and he was beaten with a baton. He received $1 million for his case. Cassandra Feuerstein, who was shoved into a concrete bench and suffered facial injuries, $857,000. Case of Jeffrey Burton, if I'm remembering correctly, he got about $600,000 after officers tackled him when he was having a mental health episode. So as you can see, the cases are all over. It's going to depend over the severity of your injuries, how bad you were hurt, and the egregiousness of what the officers did. Obviously, if the officers were acting more callous, it's very likely going to result in like a higher settlement or a higher award at a jury. So let's look at what really factors into the amount that you might get. So like I said a minute ago, the severity of the injury, you're going to look at the strength of the evidence. Also, the media attention is going to be important. The jurisdiction it happens in, whether the person who was injured was unarmed, whether there's video, all of this is going to play a role. Wrongful death cases typically get higher awards, especially if there's clear evidence that the force was unjustified. So there you have it. That's a comprehensive overview of police brutality lawsuits. Let me go back and hit some of the key points. So police brutality or excessive force is when an officer uses more force than is objectively reasonable under the circumstances. The legal standard comes from a case of Graham v. Connor, and we judge an officer's actions from the perspective of a reasonable officer on the scene at the time, not with a 20/20 hindsight. But that does not give police officers unlimited authority. You have to remember that not all use of force is excessive. Officers can and often need to use force when the severity of the crime or the threat posed or the suspect's resistance justify it. The key is going to be the proportionality. When a police brutality or an excessive force lawsuit, you need to prove that the officer was acting under color of law, like they were on duty doing the job of an officer, not just off duty getting into a bar fight, and that they violated your constitutional or other protected rights. So the evidence is going to be crucial, especially video footage, which has really revolutionized these cases. So you can sue not just the officer who harmed you, you can sue bystander officers, you can sue supervisors, sometimes the police departments or the sheriff's departments, you can sue the municipalities, but you're going to run up against qualified immunity in every case. And this shields officers from liability unless there's a prior case with nearly identical facts establishing the conduct was unconstitutional, or it's just so plainly obvious that the conduct was unconstitutional. And so this clearly established law requirement has been established as almost insurmountable when it comes to getting justice in these cases. If you do win, or if you settle, you can recover compensation for your damages, like your medical bills, lost wages, pain and suffering, emotional distress. You can go after punitive damages in some cases. So in 1983 claims you do get punitive damages. The settlement amounts are going to range from like tens of thousands up into the millions. And again, that's going to depend on how severe the injuries were and how egregious the actions of the officer were. So one final thought, these cases are incredibly difficult to win. The legal system places a lot of hurdles in front of people bringing those claims, but when officers step over the line, accountability matters. So not just for individual victims, but for all of us, right? So bringing these types of cases help to make us all safer from officers who ignore your constitutional rights, use excessive force in violation of department policy and in violation of standard policing practices. If you believe you've been a victim of police brutality, document everything, get medical attention, and consult with an experienced attorney who handles these types of cases. They often fall under what's called civil rights, and we may think of civil rights, as marching for equality and things like that. But these are civil rights claims because these are cases to protect your rights under the Constitution. So, as always, thank you for tuning into the Ask Rusty Law Podcast. If you found this episode informative, if you found it helpful, make sure to like and subscribe. Please share it with somebody that you may know who needs this content. As always, stay safe and stay informed.